There are two forms of discrimination. One is called disparate treatment. The other is called disparate impact or adverse impact. In both situations, we are hiring or refusing to hire for a particular position, or, which is disparate treatment, or we are having an unintended impact on people, meaning that we hold them to the same standard, but for some reason one group is discriminated against more readily than the other. Let's start with disparate treatment. Disparate treatment basically means if you are in a protected class based on sex, race, color, etc., if I am making a hiring decision, I am not allowed to say, I will not hire you because you are black. I will not hire you because you are white. I will not hire you because you're male. I will not hire you because you're female. I will not hire you because you're a Christian. I will not hire you because you're not a Christian. Because those are categories. Race, sex, religion are protected categories. They're non-job related categories. And if I say to one person, you're okay, but the other one you're not, and it's not related to the job, then that is a form of illegal discrimination. And it means I am intentionally and purposefully treating somebody differently. Now, that's different than disparate impact, or as I often will call it, is adverse impact. It gets at the same thing. I like adverse impact because it differentiates it from disparate treatment, so it's easier to remember. Either way, adverse impact or disparate impact is about, we have a policy. Let's say we want to require a high school diploma for everybody who wants to work for my company. And in that situation, you would think, well, then everybody, no matter what, as long as they have a high school diploma, will be more likely to get a job. And there should be no discrimination involved here, right? Right. Well, actually, that's not the case. And this was the watershed case that changed the way we think about discrimination. There was a case which is dealt with a gentleman who was looking for a job to go work for a company, and he was told that he needed a high school diploma to do the job, which on its face value doesn't sound like an unreasonable expectation. But as you dug further, number one, there were many, many people working for the company already who that did not have a high school diploma. So you wonder, okay, so then why suddenly did the job get more difficult? Nope, job didn't get more difficult. Job was the same. Nothing changed about the job. It was only the criteria for hiring. So again, you might argue, still not a problem, right? Because if just most people have a high school diploma and they'll get the job. Well, that wasn't necessarily the case. Because when you dug into the local area where this region was doing their hiring, this case was called Griggs versus Duke Power, and in the area around Duke Power, black people were disproportionately less likely to have a high school diploma than were white folks who lived in that area. And this is long history, Jim Crow, discrimination, all these kinds of things. This is why we needed to have Brown versus Board of Education to make sure that we had good high school education and opportunities for people that were similar across the board. So when they looked into it, they were able to demonstrate that black people, number one, were less likely to have high school diplomas. So it does have an unintended impact against black people. But that in and of itself was not as much of the problem, because if the criteria was legitimate and you could demonstrate that a high school diploma was needed and that you could not do the job without it, then it kind of doesn't matter if there is a form of discrimination in that case. Because if the job requires a particular skill set and you don't have the skill set, then you're not going to be able to do the job, period. What hurt them was the fact that people were in the company and able to do the job without a high school diploma. And there was long evidence, documented evidence, that people had and successfully completed the job without a high school diploma. That was the downfall. Because if you have a job-related criteria, that's the be-all and end-all. If your job criteria is valid, if it's applicable, if it really has a tremendous impact on someone's ability to do the job. If someone doesn't have the skill set, they shouldn't get the job. And the law supports that. And so in the Griggs case, they realized that the high school diploma was not a valid tool. It doesn't mean that the company was intentionally trying to do harm. And in fact, I don't think that they were trying to do harm. I think that what they were trying to do was to upskill, to make it feel like, yes, we want to make sure we've got people who are qualified to do this work, but they forgot to investigate to see whether or not anybody was actually doing the job without that high school diploma. And so that's where the rise of adverse impact or disparate impact came into play. So the major difference between the two is that disparate treatment is intentional, and it's about how I treat a person. And disparate impact or adverse impact is not necessarily intentional. It's actually, I'm treating everybody the same, but in treating everybody the same, we are having a differential impact on one group that is discriminatory, and we need to rethink that criteria. So let's go into disparate treatment a little bit more deeply. How do we test for it? How do we know whether or not disparate treatment actually occurs? And the first thing that's important is we have to recognize this thing called a prima facie case, which means preliminary evidence on its face value. And the prima facie case is basically saying this is the beginning of the process. Do we have enough evidence that says this could have happened? Now, that doesn't mean that we're proving it right or wrong. It just means that there is enough evidence to say it could be happening. And then that requires us to go into discovery and then go to court and to be able to demonstrate yes or no that illegal discrimination did occur. So the first thing we need to have is to establish the prima facie evidence. So what is the prima facie evidence? The prima facie evidence basically says a person applied for a job. They were qualified for the job. They meet all the standards that was listed in the job listing, the job description, and they applied for the job and didn't get it, and someone lesser qualified got the job, or the job is still open despite being eminently qualified for the position. Now, does that mean under every circumstance that somebody who was qualified for a job and didn't get it is not a good match for the company? And of course, that's not necessarily the case. Often, someone interviews for the job, it's not necessarily discrimination, and they really just are not a good match. You might say, they answered these questions incorrectly. This is not the kind of personality we're looking for to work for us, but it's got to be well documented, right? You can't use it as a pretext to say, oh, it's just an excuse because really I was the only black candidate and therefore they didn't want to hire me because I was black, or the only female candidate or the only male candidate and therefore I was not hired for those reasons. So pretext is where they pretend there's a real reason when in fact it's still the underlying reason is discriminatory. So once the applicant makes their prima facie case, they applied for it, they were qualified, they interviewed, and either somebody lesser qualified got the job, or the job request was still open. The burden of proof then shifts to the employer, and this has been upheld by Congress in the Civil Rights Act of 1991 that amended the original Civil Rights Act, and it basically argues that it is then up to the employer to prove they didn't discriminate, because otherwise, if they don't do a good job of proving they didn't discriminate, then the assumption is that they did. So they have to show ample evidence to prove that they did not discriminate based on race, sex, color, religion, national origin, et cetera, et cetera. And you might say, well, why can't the employee just make their case? Well, because the employee doesn't have access to the thought process of the organization. So how can they make the argument that they were not being discriminated against? Or because it's up to the employer who is making the decision to show that the decision was based on job-related criteria, the person was not qualified for a whole host of reasons, or here's the answers that bothered us and we did not like the way that they answered this question and we thought that that was problematic, which is why we didn't want to hire them. And so that's the process by which we can go through that. The employer has to demonstrate a non-discriminatory reason. Now, sometimes there are things called mixed motives. And mixed motive cases basically say there is a discriminatory reason and then a non-discriminatory reason. And a big case in this for this arena was Price Waterhouse v. Hopkins. And in Price Waterhouse v. Hopkins, Ann Hopkins was told she was brusque with her employees, that she treated them with disrespect, and she was not feminine enough. And she didn't wear makeup, and she didn't wear dresses. She only wore suits with pants. So therefore, if she were just more feminine, she would have been promoted. So even though there might have been legitimate reasons for not promoting her by basically saying you are not good with your employees, they have problems with the way that you treat them, so therefore we're not going to let you be promoted. They also added, and if you were just a little bit more feminine, you would have gotten the job. That was their undermining. Because even if there were legitimate reasons, we don't know how much those illegal reasons tainted those legitimate reasons. And just because there may have been legitimate reasons, they were still illegal reasons that influenced the decision process. And so therefore, if it's partly wrong, it's all wrong. So what can an organization do if they have been told that they are being accused of disparate treatment, where they have treated somebody differently because of their race, sex, color, religion, national origin? Number one, they have to show that non-discriminatory reason, okay, first and foremost. Second, they have to, in addition to that, they may also need to prove that there is a bona fide occupational qualification for why I only want to hire a man for this position over a woman, or a Christian versus an atheist for a particular position. And a BFOQ, there is no BFOQ based on race, right? But there are BFOQs based on religion as well as sex. And here's one example, right? If I have a role that I'm hiring for, like let's say I'm a Catholic church and I'm hiring a priest. And if my religion says I can only hire male priests because that's the tenets of the religion, a woman cannot sue for discrimination based on that, because the religious dictates are you have to be a male in order to be a priest. Similarly, if we have a situation in a maximum security prison and we're dealing with a male prison guards, and the dangerous aspect of having a female work in a all-male prison, particularly with a maximum security prison with very egregious, violent criminals in there. If they believe that women are at risk, they can deny women jobs in those situations. Now, is that always the case? No, because there are plenty of women I know who do work in maximum security prisons, and they do the jobs very well. They are strong themselves. They have the ability to defend themselves. So it would be very difficult to prove that, but it's certainly possible. So, but that gives you some examples about why I would want to hire a man over a woman to be a priest, or why I might hire somebody who is Lutheran to come and work at Lutheran family services versus somebody who's an atheist. I have the right to hire people who share my religious beliefs to work in my religious organization, and I can do that.